The following program, offered by Fox 19, includes lawyers licensed in Kentucky. For those lawyers to maintain compliance with the Kentucky Bar Association requirements, the phrase, "This is an advertisement," must appear on the screen. Moore Law is underwritten in the public interest by the Moore Law Firm, a legal professional association. This is Moore Law on Fox 19.
Welcome to Moore Law. I'm Dan Moore, and for Deb Haas. Today we're giving you the chance to ask a question about any area of the law, from criminal defense to workers' compensation to wrongful death to wills. No legal question is off limits. Do you need an attorney? If so, what type of attorney would be right for you? Is there a time limit to get your legal problem solved? If you have a question about the law, this is your chance to ask us anything. Give us a call, 513-421-4691. But before we get started today, let's check our upcoming dockets for the rest of July. July 16th is Hurt on the Job. July 23rd, is Divorce and Child Custody. July 30th is Car and Truck Accidents. And with me this morning, of course, is Dad, Don Moore. And we're going to have some fun this morning, aren't we, Dad?
We're going to have a lot of fun. You know, I'm really excited. One, this is Stump the Attorney morning, so everybody gets to just ask anything they want to ask. Callers drive the whole morning, and hopefully we're going to be able to give them the information they need. Two, we've got just the man to help us. That's John Caldwell. John, welcome.
Thank you for inviting me here.
Well, I'm glad you're able to come. John is from West Union, and in fact, his office is right across from the courthouse in downtown West Union, Adams County. He's been practicing almost 40 years, and we are alum of the same law school. He went to NKU right across the river in Northern Kentucky, Salmon P. Chase College of Law, which is where I went. Tell us a little bit about your practice.
Well, Don, I do a wide variety of practice. I do civil litigation. I do some criminal defense. I used to do a lot more, but not now. I do some debtor defense work. I do some bank work with some fine institutions. I do tax preparation, real estate probate. It's never a boring day at the office.
And so you are just the guy we need for a Stump the Lawyer show. I'm glad you're here.
Glad to be here.
Now, I understand we've already got some calls. I think Ann from Cincinnati is on the line. Ann, tell us what you got.
Okay, I work for a company that has a non-smoking policy. You can't smoke on their property. So they tell us we have to leave the property if we want to smoke. So they tell us that we have to clock out for our break to do this. When you clock out to do that for 10 to 15 minutes, they are deducting money from our check for it. If you don't smoke, you get paid for your break. So I was wondering, can they legally do that?
John, what do you think?
Well, Ann, do you have a union where you're employed?
No.
Okay. Do you have a policy manual?
We do.
I would look at the policy manual and see what it says in the policy manual, the employee policy manual. Also, I find it rather difficult to understand why the employer would make you clock out if you were on your break to go smoke, yet other people who don't smoke don't have to clock out and get paid for their break. Makes no sense.
Right. Well, they said it's a liability issue. If we have to leave the property, that it's a liability issue for them because we're off the clock and not on the property. So they say we have to clock out. My only issue is I don't have a problem with that, but I don't feel like I should have to pay them for my break just because I choose to smoke a cigarette, unfortunately, and other people can eat or do whatever they want on their break and get paid for it.
Now, I think, I'm sorry, go ahead.
They tell me they're not going to pay me to smoke a cigarette.
Well, they're paying other people to do things that's non-smoking issues, standing around telling stories, jokes, whatever. I find it somewhat discriminatory that they're taking that position with you. And I think it's something that you, first of all, need to look in your policy manual. Secondly, you may want to talk to legal counsel about, am I being discriminated against?
Okay, great.
Thanks a lot. I think up next we have Cheryl from Fayetteville. Cheryl?
Hi. My son and I, we were broadsided in an auto accident at the end of March, and we did not acquire an attorney. He hit my driver's door, and luckily my son and I both survived. It was pretty serious. And my question is, what is the recommended amount for pain and suffering? I've heard from 1 to 3 times your medical bill. So I'm just looking for some advice. I mean, it has affected our life every single day.
That's a common question, Cheryl. That's something that we get a lot. And Dad, why don't you explain that for a little bit?
Well, I will, and you're right. It's very common. Cheryl, it varies so much. It's fact driven. 1 times medical bills is pretty much absolutely ridiculous, unless the medical bills are disproportionate to the injury itself. So let me give you a quick example of that. If you had a sore neck, you went to the emergency room, they did an MRI, they had $1,000 in bills right out of the box, or $1,500 worth of bills, then they're probably not going to pay you for $3,000 for pain and suffering when you've only been, you're able to go back to work the next day or a couple of days later. That would be a case where 1 times medicals might possibly, or 2 times medicals might possibly be reasonable. But frankly, that's just not real life. And you said it's been a protracted problem. Getting it evaluated is something that you're just going to need help with. At 3 times medicals certainly isn't unreasonable, but it varies so much. My grandfather represented a fellow once who had his arm cut off in an automobile accident. He was driving along with his arm on the door. It got sideswiped, took the arm off. He had $500 in medical bills. That was a long time ago. His case was worth a heck of a lot more than 3 times medicals. Very fact-driven. That's something you're going to need help with, and we wish you the best of luck. I hope that was a little bit of information is helpful to you.
In fact, we were just talking about that before we came on the air, and John, I think you've seen that a lot too, haven't you?
Quite a bit, especially where I practice law. A lot of my cases are soft tissue cases, whiplash cases. So we have a very difficult time with insurance companies because they have the impression now that they don't have to pay very much to settle the case, and so you really need. It's really good to talk to legal counsel. You may not use or employ legal counsel, but it's always good to talk to legal counsel to see what the arena holds for you.
Okay, I think we need to take a break now. We'll be back in just a few minutes.
Welcome back to More Law on Fox 19, your legal questions live, with local broadcaster and award-winning reporter Deb Haas and Cincinnati personal injury attorney Don Moore, recognized by Ohio super lawyers. More answers, more help, more law on Fox 19.
Welcome back. One of the things we wanted to get into as a point of interest for our public, we were talking about this before the show again, and it's something that was surprising to us lawyers. Sometimes people can be liable for some of the products that they sell at a garage sale or to a neighbor. You know, Dad, some of these are cribs and things that people use every day for small kids. Why don't you tell us a little bit about that?
Yeah, you're exactly right. This is something that was a surprise to me. There's the Consumer Safety Commission has a law that says specifically you're responsible if you sell something that's been recalled and it causes harm, which means if you've got a playpen or a crib or you've got a toy that's been recalled and you sell it at a garage sale, like frankly the cribs that we used with Dan and his brother and sister when they were little, or was used with me when I was a kid, those are antiquated, and some of those have caused injury in the past. If you would sell it at a garage sale and you actually and a person actually got hurt from it, you could be liable. So just an FYI.
Yeah, something to pay attention to. Don't just go off selling those things without checking them out. Let's go to our next caller. I think we have Betty. Betty, what do you have for us today?
Yes, I'm calling concerning landlord tenants. If tenants leave your property just basically destroyed, vandalized, if someone were to come in off the street and did what they left you, that could be a crime. But now, some of the tenants if they get bed bugs, instead of reporting it, they just move. And we're stuck with it, and we don't know you have bed bugs. Then you rent it to someone else, and when the people move in, the bed bugs come out again. Do we have any recourse as a landlord?
And Betty, I'm assuming you're a landlord. Is that right?
You are correct.
Yeah. And bed bugs, big problem in this area.
Yes.
Sure is.
One of the hot spots in the United States for this, Cincinnati is. John, what do you have to say about that?
Well, the landlord obviously has recourse. The recourse, first of all, would be to sue the tenant. Most of the time when you sue the tenant, a lot of times the tenant has nothing to get. The old cliche of sue a beggar, get a louse.
In this case, a bed bug.
A bed bug in this case. But you can go after the tenant. And it is a problem. And I think due diligence on your part, Betty, would be that regardless of the cost, you have to have an exterminator go in and check that property before you rent it again. Because otherwise, you may be subject to some claim by a tenant who says the property was not clean. But you can sue your old tenant. If the tenant has a job, you can get a judgment, and you can garnish the tenant, which we do quite often.
One of the things, though, that I ran into is that you got to show they did something wrong. And a lot of times, they may not have done anything wrong. They bought something. We were talking about a garage sale just a minute ago. They bought a piece of furniture at a garage sale, and they bring it in, and they're doing it innocently, and then they discover, wow, they've got this infestation. Maybe they think it's your building or your problem as opposed to theirs, so they take off, and they just don't they don't believe they did anything wrong. If they have renter's insurance and they did something wrong, as in negligent, then it's possible there would be coverage, but you're going to have to show they're liable. And showing they're liable might be a pretty tall order. So not an easy fix, actually. And the bed bug business has been hard on everybody in the tri-state area.
And that's a very good point. The liability issue is always a problem.
But one last point on that. One of the things I've seen, Betty, is that some landlords have put in their leases a provision that says that the tenant has to notify the landlord as soon as they know about the bed bug problem. So if you can do that in your leases, then that can kind of bestow some liability if they don't do that, even though they're not responsible for the bed bugs being in the property to begin with.
You know, and just one other thing that I want to mention, and that is, in the beginning of your question, you talked about vandalism, or actually when someone's damaged your property. And what you had to say was absolutely correct. If they damage your property on purpose, then they are liable and could be criminally liable. Like if they steal things, they steal copper out of the building, or they steal an air conditioner, or they just do malicious damage to something, that could be subject to criminal charges, which can also lead to recovery for the landlord, because as a condition of probation, oftentimes courts will order restitution. So you kind of ask a two-part question. I think it was worthwhile to cover them both, because I think those are things that come up a lot.
Thanks a lot, Betty. Our next caller is Eric. Eric, what do you have for us this morning?
Yes, I live out in a township that has no zoning, and we're allowed to shoot firearms 27 days a week, 24 hours a day. And my neighbor probably has shot a gun 10 or 15 times in the 27 years we lived here. He is now building a fire range, and it's about 300 feet from my property line, and it shoots over top of my pond, my deck, and my children's playhouse for my grandchildren. And I have no rights over the noise, no rights of getting him to stop. The law told me to quit calling him and having them come out, because he's allowed to shoot. He's allowed to shoot pistols, any type of weapon he wants, a firearm.
And Eric, these problems come up from time to time. What you're describing is really a nuisance. We'll get into that in just a minute. We need to take a break. We'll be right back.